Okay, ladies and gentlemen, I think we should get underway because we have a packed agenda for you this afternoon. Good afternoon and welcome to this S&D Group workshop on workers' rights and fair mobility, the role of the European Labour Authority. My name is Jackie Davis. I'll be moderating our discussions and I have the privilege of, I hope, moderating a very interactive, very lively discussions. We have some short presentations in each panel, but also plenty of time for conversation. To help us with that, we have our wonderful interpreters. They want to make a little announcement to you. Let me first tell you which languages we have. We have English, Spanish, French, German, Italian and Dutch. You see the numbers on the wall round you, but there is something they would like to tell you, so I'm going to give the floor to them.
Thank you very much and good afternoon from the interpreters. We regret to inform you that due to a labour dispute that is ongoing with the management of the European Parliament on our newly imposed working conditions, which we feel will adversely affect the quality of service that we try to provide for you, we will be stopping at 6:30, 18:30 this evening, precisely as scheduled. Thank you very much for your understanding and attention.
Thank you very much for that, and I should actually add to that that my aim, the programme has us finishing at 6:15, and my aim is to finish precisely on time because I know many of you have places to go and people to see. So we will stick to the timetable. We are going to have, as I mentioned, two panel debates. I'll tell you a little bit more about them later on and how they're going to work, but it's first my pleasure to give the floor to Agnes Jongerius, MEP, who is the S&D coordinator on the European Parliament's Employment and Social Affairs Committee, better known to many of you as EMPL, our host today. So over to you to kick us off.
Thank you, and also thanks to the interpreters. And I think it's very wise that you ask attention in a setting as this for your own working conditions. So bravo for that. Then for me, a warm welcome to you for a topic on quite a warm day. But you all choose to be here, which I find a great honor and a privilege because in a way, I think it's important to note that together, and not only the members of the European Parliament, but also our stakeholders, we are working towards a more social Europe, and it goes in small steps, and I must say sometimes not as quick as I should like, but perhaps it's also allowed to say that we won a big fight last week, of which I'm personally quite proud of. Equal pay for equal work, the same workplace, will be a fact. There has been a decision from the European Parliament. Member states have now 2 years' time to transpose this in national legislation, and for me that's important because it makes colleagues again without wages being undercut and without honest businesses being put out of business. And before someone from the floor is making this remark, we still have the transport sector to take care of. So the business has not been settled yet, but it has been a step, and it's time for a next step now, because if the rules we are making are not being enforced, we can draft as many rules, as many directives and regulations as we want. We won't bring them into real change. And about real change, I'd like to make a few remarks in my opening statement, because bringing about real change for people, making sure their wages, their working conditions and their social standards are being enforced, I think this is what we are talking about if we are talking about the ELA proposal. We wanted, and we have created an internal market years and years ago, but proper checks on fair functioning of that market are until now can I say, still lacking. And as Social Democrats, but not only we are aware that markets cannot be left on their own. That's the case for capital markets, for financial markets, for markets of goods, but also for labor markets. And when fraud, abuse or misconducts currently cross the borders of the member states, our national labor inspectors stand a little bit powerless. And as a result, very often investigations are not being conducted at all. And without the hindrance of the institutions that have once been established to protect workers' rights, to check working conditions and to ensure fair, level playing fields for companies, it's too easy for not well-intended companies to exploit people. Our commissioner, I say this as a member of our EMPL committee, our commissioner Marianne Thijssen, is well aware of the lacuna in the internal market, and for that reason, I think we should say it's praiseworthy that she took the initiative in proposing to establish an European Labour Authority. I welcome her initiative, but I also have some requirements on how I think the ELA could really become a serious and effective authority. Before I elaborate on that, let me give just one example. And in the European Parliament, we say then an example of the country I know best, which is in this case the Netherlands. The case is a case about Romanian metal workers in a Dutch shipyard. They were posted via a temporary agency company for wages they hardly can describe as wages. An hourly rate of below €2, so less than €2 an hour. And that's what's quite impressive, that although they were living in a foreign country, in the Netherlands, in lodging provided by their employer, they decided to come into action and they went into strike. And with the help of the trade union, FNV, of whom they become a member at that moment, they filed a case in court. The union undertook a mission to Romania to find out the shipyard there that had posted the workers, and discovered this has been a letterbox, I should say, established by the same Dutch shipyard owner who previously laid off his personnel while hiring the people from Romania. So it was a Dutch company opening up a letterbox in Romania. And in this case, the Dutch inspectorates asking for information with the Romanian colleagues didn't receive an answer. And I think you can imagine what an operation it is for workers who are living abroad and for trade unions who are checking the premises on the other side of Europe. One can also get the picture on how thorough and sincere cooperation between two national inspectors could solve these issues in a much more effective way. But this cooperation, sadly said, doesn't come about naturally. It needs change in practice, and it needs change in practice at the European level, but also, or perhaps mainly, at the national level. And I think the ELA, the European Labour Authority, could become an authority with a proper mandate, so to be able to act in cases as this case. I cannot imagine that a majority in the Parliament doesn't want an effective ELA. And I think today we're going to talk about how are we going to get to an effective ELA in the end of the proposal. Because I think we should get rid of the voluntariness. Otherwise, a single unwilling or indifferent member state can grant inspections of the authority that have been beneficial to many other member states. So I think further cooperation between willing member states is a step in itself. But the proposal as it is now is aiming to raise the bar. So not only working on voluntarily cooperation, but also raising the bar in much more, much more force into this good cooperation. I think today we're going to talk about sanctions, the possibility to sanction the companies, because if Jean-Claude Juncker referred to the banking authority in proposing the European Labour Authority, he also raised the idea of establishing an ELA. The banking authority has the authority to sanction banks. So if we are working from this comparison, perhaps this is also an issue for the ELA. Before I take too much time, let me end by saying I know the procedure is going to be a little bit as a roller coaster. Because we are ambitious in the European Parliament. We also have an ambitious rapporteur on this file. I welcome my colleague Jeroen Leenaerts, who is also Dutch, which is of course a quality stamp. Jeroen is sitting over here. He is going to present his first proposals next week, in 2 weeks' time. So I think it's very good you have the time to come and listen here. You know we're all impatient, and we're not only impatient for the cause of a good European Labour Authority, but also because we'd like to finalize this file before the end of the mandate. So this will be a lot of thoughts floating in the room today, helping our line of thinking, helping, I do hope, also Jeroen's preparation of the file. So I'm glad you're here. I'm glad you took the opportunity to stay inside instead of enjoying the sun in a Brussels bar or restaurant. I'm very curious about the two speakers, and I leave it all to you.
Thank you very much indeed, Agnes, and thank you for that inspiring start. And we promise, ladies and gentlemen, to make your decision to stay in here worthwhile.
Absolutely.
Thank you very much indeed. So, as Agnes just said there, if the rules that we are making are not being enforced, we can draft as many regulations as we like. We will not deliver real change. And she talked about how she believes the ELA could become a serious and effective authority. What we want to discuss is what precisely are the issues that need to be tackled? What is the problem? If you like, the diagnosis. That's what we're going to do in our first panel. I hope to hear about the key challenges that need to be addressed, and then drill down into our second panel into how do we ensure that the new authority is indeed serious and effective, and look at the detail of that proposal later on. And Agnes, maybe we'll hear from you from the floor later. If you feel inspired to join our discussion again, I will be looking at you and give you the floor if you want to. So, as Jean-Claude Juncker said in his State of the Union speech in 2017, we must make sure that all EU rules on mobility are enforced in a fair, simple and effective way. Agnes mentioned the connection and the comparison he made with the European Banking Authority. I'd like to come back on that later on. But as I said, in our first panel, we want to analyse the current situation and identify key challenges that need to be addressed to ensure that effective enforcement of EU law to protect workers' rights and fair mobility, and consider whether a new European Labour Authority really can help to tackle them. As it stands in the proposal, or maybe later on we will, in our second panel, analyse in more detail what might need to be changed to achieve that goal. So I think our speakers are now... Erica, why don't you come and sit next to me? You're far too far away. No, Agnes, she's gone to the audience, so you come and join me, otherwise I'll feel a bit lonely here in the middle. So we take that one off and we pop yours there. Super, marvellous. So, with me, let me introduce all three of them for our first panel to discuss the current situation. We have Erika Metzger, who is the Deputy Director of Eurofound. We have next to her Dana Schäfer, Head of the European Department at Sokabau. And next to me on this side, Edwin Atema from the Netherlands Trade Union Confederation, FNV, the largest trade union in the Netherlands. They are going to make opening remarks of 7 to 8 minutes each, and panellists, forgive me if I am quite strict about that, so we have plenty of time for our discussion. Once they have spoken, I will have a few questions for them just to get our discussion started and cover some of the basic issues I'd like to address, and then I will open up to all of you. And I should stress, in our discussion, you don't need, if you have questions for our panel, great. If you want to comment on what you're hearing, as long as you are brief, that's absolutely fine. We have a lot of expertise in the room. We would like to capture it. So, Erika, set us off, will you, please? I think you need to use this mic.
This one?
No, that one's having a bit of trouble today. Okay. So if you use that one, and if you use the one to your right, they had a bit of trouble in the first session. There we go. Over to you.
Dear Jackie, dear all, thanks for having the European Foundation for the Improvement of Living and Working Conditions here in the workshop reflecting about the European Labour Authority. You know, we have expertise since 1975, 43 years, dealing with working conditions, living conditions, social dialogue, industrial relations, and of course the issue of labour mobility, migration, impact on working conditions is a horizontal issue for Eurofound in general terms. We are glad when we were glad when we heard in September by President Juncker in his State of the Union note that he thinks the European Labour Authority should be, so to say, a building block of social Europe. And in the light of the upcoming elections next year, there seems to be a need to regulate something. So in this regard, we very much welcome that also in the year of 50 years of labour mobility, because fair, decent labour mobility is a cornerstone also as regards the acceptance of Europe from a citizen's perspective. We think that there's an added value, a potential added value of the ELA. There are gains to be made in relation, was already mentioned by Agnes, to the overall coordination of actors in the field working in the area of labour mobility in general terms. Also, the issue mentioned the potential efficiency gains through the pooling of human and financial resources as described in the regulation. The issue is, and I think that's not clear at all as far as we can see, the issue is how all these bodies, instruments, committees, and institutions at national member state level and EU level would be integrated into a work together with the ELA, how overlapping of tasks and responsibilities would be really avoided. Looking at all these presentations, including the impact assessment, what Jan Kremers and others did, there seems to be a lack of analysis and diagnosis. Which gap of policy action do we want to tackle? Which gap of data maybe ELA could collect in the future? And what do we really want to tackle? As we know, labour mobility law enforcement is the sovereignty right of member states. So if Europe wants to design something as the ELA, it has to be thought through in a great detail. In Eurofound's view, it would also be conceivable that the ELA could broaden its remit and not focus exclusively on cross-border issues associated with the mobility of individual employees and workers. There's also, of course, and for sure, a collective dimension to cross-border work issues, in some cases regulated at EU level. A few examples are the representation of workers' interests in companies, mentioned by Agnes also earlier, active in more than one member state, or possibility for cross-border collective bargaining and agreements. For example, we have the European Works Council information and consultation rights in European companies and cooperatives. We have the European framework agreements. There's currently no European level extrajudicial, I always have a problem with pronunciation, judicial, you know what I mean, mechanism to help to resolve disputes affecting actors in more than one member state through conciliation and mediation. A voluntary conciliation, mediation, and possibly even arbitration, that's a more firm law-based, let's say, a mechanism in the framework of the upcoming ELA could assist in concluding agreements, resolving disputes thereof, and in interpreting their content. There could be some policy shaping bottom-up. This could be done either directly or by supporting and embracing national sovereignty bodies when they need an EU common interpretation to mediate in disputes based on EU regulation. The establishment of a central register of companies falling under the European Works Council Directive could be considered. That would be somehow a soft law approach, and let's say not exactly a law enforcement, it would be, let's say, a mechanism of integration and soft law cooperation. The ELA will not only be dealing with tackling challenges as they present themselves today. Changes in the world of work, and you worked about that very intensively, particularly those linked to digitalization, will have a tremendous cross-border dimension. Crowdworking, just an example, facilitated via digital platforms, by definition are cross-border phenomena. ICT mobile work is also a reality that might raise questions on which rules are applicable. When establishing the ELA, it should therefore be considered to ensure access to information based on the monitoring of drivers of labor market change and changes of the world of work. It's a moving target where I'm not sure how the ELA configuration should look like to be really effective and efficient. Digitalization and other future developments have to be considered both as regards the new opportunities, but also as regards emerging challenges. This would be a requirement for developing action in support of desirable futures and to adapt rules and control mechanisms to counteract unfavorable developments, because one core policy goal seems to be to avoid fraudulent forms of work, to really make decent labor mobility work on a workplace, very practical, individual, but also collective level. An ELA has the potential to fulfill concrete needs and expectations of workers, I would say, as well companies and public authorities in relation to labor mobility and an inclusive and fair European labor market. Making visible to all citizens, and I guess there's a huge credibility need, that it's more than buzzwords, that we want to take action for fair worker mobility. Serious thoughts have to be delivered how to do this really, and not ending up, to be frank, with buzzwords, law enforcement, yes, we will do it. How do we do it? What are the remits of member states in Europe, and what can Europe do? A second brief part of my first remarks is dedicated, of course, to the current evaluation of our agency, together with our sister agencies, CEDEFOP, OSHA, and Training Foundation. We are all under the remit of DG Employment, Commissioner Thyssen. In the evaluation report we received by ECORIS and PPMI in December last year, the evaluators have been asked to have a look how ELA could be considered as regards a task for one or two or three of these agencies. According to the evaluators, potentially all four agencies could support and contribute to the work of this new body. I would agree on that as long as it's about social science support, providing data, doing case studies. That would be an option for the future. Eurofound's topical areas of expertise correspond in many ways with the requirements of the authority. It's about research methods, harmonizing European data, and so on. For example, at the moment in work program 18, how many minutes? One. Final remark. In our current work program 18, we do a study with our network of national correspondents. They collect data in all 28 member states as regards posting of workers. Which data gaps do we have? Which knowledge gaps do we have? To have some evidence which could also help the ELA in the Constitution. I skipped the rest of it. Thank you very much.
Lots of time to discuss those and other points, so we will come back on them. I just want to get that basic picture in place, and you've identified already some key questions. What are the gaps that we're trying to address? How do we make sure that this new authority does indeed target those gaps, there's not overlap and duplication, the who does what question, and you there really suggesting some quite significant broadening of the scope of its work. It'll be interesting to see whether our other speakers agree. But let us continue to build the picture. Dana Schäfer from Sockerbau, your thoughts, please.
Hello, Dana Schäfer. I prepared a small presentation, but it was somehow went to the spam. So it will be.
I think we don't have a remote control, so you may need to change desks just for this part.
Yeah. Okay, and the micro. So, the presentation will be available on internet later on. So let's come to Sockerbau, who is a paritarian institution set up for the construction industry in Germany. It offers special solutions for the construction industry on the holiday fund scheme and also on pensions and vocational training. What I deal with is posting of workers to Germany, and therefore we have colleagues that speak 14 languages in the European department. Further on, I brought you some figures about the posting of workers. As you might discover, in between 2012 and 2017, the number of posting of workers has raised in total by 53% during this time for the companies and by 47% in this period by the workers. So there is a relevant number of posting in the construction industry, not as assumed in the service directive by the European Commission. If you are interested in seeing the numbers broken down to the several countries, you might wait to see it more clear in the presentation. So now I brought 4 practical cases of companies that we are really dealing with, and it's on the one hand the problem on the A1 certificate. I report you a case of a Slovakian company that fulfilled structural work in Germany. Therefore, it posts own workers and so-called self-employed workers. All workers fulfilled the same work. They got all the material. They worked together. The coordination was by the company. In Germany, there was an inspection on the construction site. The custom authorities found that all people were seen as workers, but they didn't stimulate the withdrawing of the A1 certificate. So finally, we decided to set a judicial claim because the holiday fund scheme is just available or is just gaining advantage for workers, for blue-collar workers, and we tried to claim the benefits on basis of the gross wage for all of them. In the first instance, we were not successful with the claim, but the appeal is going on, the appeal process. The second practical case is on temporary agency work. Here we are dealing with a Dutch case. The Dutch company lends workers to German and other companies, and the temporary agency work, the temporary employment in the construction industry is not allowed in Germany. You can only do it when you are falling under the same collective agreement, so in between construction companies, or as a posting company, you have to have to be 3 years doing construction work. Therefore, nevertheless, you need a temporary employment license to fulfill construction work. And here we have the case that the Dutch company is in possession of a temporary employment license, but there were doubts coming up whether the Dutch company is a real construction company, because we found out in the commercial register that there was no worker in the Netherlands. We were getting in touch with the German and custom authorities and also the German labor authorities, but there the responsibilities on posting cases were not clarified, and there were only inspections in Germany on the construction sites or in the offices, but not in the Netherlands. So the only information we exchanged was with the Dutch social partners, TBB, on this company, and we still try to find out whether this company is a construction company or not. Because if it's not a construction company, it's not allowed to have these allowance to lend workers. The third practical case is on bogus self-employment. We have seen that there were several companies seated in Slovenia posting workers to Germany. In practice, these workers are from Bosnia. We know this because of their home addresses and their names and languages they are talking to us in. And we registered that there is a very high fluctuation between the employers already within 1 month. And the company is very often not having any field of activity in Slovenia. The company is closed down very soon, and when the custom authorities come to the construction site, so there's no way for us to to catch them. And last but not least, I would like to talk about the enforcement abroad. Here I can tell you it's very costly and it takes very long. Example is a Bulgarian company. It posted 90 workers to 5 construction sites in between March 2004 and August 2005. Due to investigations of the custom authorities, we found out that the minimum wage was not paid to the workers. And only in May 2009, we were able to set a claim to the German Labor Court for contributions to the holiday scheme on basis of the correct minimum wages. In February 2010, we got the judgment, whereafter we were entitled to 12,000 euro of contributions. We found out that the company is still existing in Bulgaria, but there was no payment of the company after the judgment, of course. In March 2012, we found a solicitor in Bulgaria, solved all the formalities with the solicitor, and in December 2012, the enforcement process was started. Another 8 months later, in August 2013, we got the first money out of the enforcement, and after that, a payment by installments followed. So all entitlements and interests were finally paid in 2018. That's the practical cases.
Thank you very much indeed, Dana. So some very clear examples there of the sort of issues that need to be tackled. I'd like to talk to you later on and get a bit more detail in terms of the challenges that you have faced. You highlighted where you have succeeded, what you've succeeded with, but we can also build on that in terms of the challenges you face and therefore where a new authority could really have made a big difference in your view. But we'll come back on that later on. Edwin Atema is going to complete the picture for us, and we have a video in this as part of this presentation, so we'll just get that ready so that we're ready to rock. And Edwin, as you see it, the key issues that we need to address, the current diagnosis. Over to Edwin first, and then he'll tell you when to press the button.
Yeah. This company, so first of all, I work for a trade union foundation grounded by the trade union FNV 25 years ago. We do grassroots research and civil enforcement in road transport. We cooperate with FNV and the International Transport Workers Federation in London. I like to start to draw the clear, simple picture of how workers see it. As we all know, in Europe, capital, companies and workers move freely across the European borders. To keep this system in balance, we all agreed on social legislation and something we called a fair market. But to enforce these rules, we have borders. So for the public enforcement, this social Europe stops at the border. We see on our daily basis, if we do our grassroots research, how freely we as civil enforcement and research department move over Europe. And we feel ourselves like the social Europe, a social Interpol of Europe. Let's say a few years ago, everybody said, these guys are crazy. And see here how big the topic is in Europe. Nobody can deny anymore what's going on the labor market. If we read the report on Creta about human trafficking, what's published a few months ago, we see how poor the labor market is. We see huge numbers of victims of human trafficking and only a few member states who are active in enforcement. Agnes joked about Jeroen Leenaars being a Dutch quality standards on this issue. But for me, sitting here, it's kind of strange because in the political arena, this subject of the labor market is framed into an East and West subject, which is not true. It's about, for us, it's about Dutch quality standards in abusing workers. It's what my daily work. We pointed out the formal countries where workers are employed, like Slovakia, Romania, Bulgaria. But the heads and minds under these constructions are always mostly Western European labor criminals. We cannot see it else. I took with me today Daniel Iacob from Romania. He was employed in the Czech Republic. He drove a truck in Western Europe. He drove all the multinational companies. He was in the company once in the subsidiary in Slovakia, in Czechia, to sign his labor contract, then drove a truck in the West. The authorities said there's nothing illegal under this case. We did our research, talked to workers, went to other countries, we saw letterbox companies, we document cases and actually enforce the authorities to enforce. It's crazy that we as trade union need to take a role in enforcing the authorities to do it. And this case ended in the company was criminal prosecuted, letterbox companies were announced, illegal practices, it's a clear picture. And for our workers, it's strange that we as trade unions need to be the balance in this whole system. Then we think that ALA needs strong public-private cooperation in a strong role of trade unions. Because we as trade unions are the ears and eyes of the labor markets. Symptoms, what we see in European reports, we see it years and years and years already. And it's so bad that a lot of workers lose the trust in our beautiful EU. Employers and the capital moves freely, enforcement stops at the border. So our goal is that enforcement cannot be depending on political priorities from member states. We had a case in Cyprus where a Dutch agency was based. we saw that Dutch workers were recruited, put on the payroll in Cyprus, and the Dutch authorities weren't even allowed to do a research in Cyprus. Unbelievable. We make, to show our work and to show a snapshot of the reality, we from now on document our field research, and I like to show a part of a movie about a Dutch quality standard transport company who had there were anecdotic stories about workers from the Philippines. The authorities did a raid, found nothing. We did the research, and it's not that I'm very smart or clever. We did a research, and in 2 weeks, that guy there from the Philippines was announced as official victim of human trafficking. But a Dutch employer whitewashed the labor exploitation with a letterbox from Slovakia. So maybe it's good to show the movie, and then we see how much time I have for the second part.
This company, they exploit us just like a dog that they can buy. Yeah. They can buy a dog and then they will bring in their house, and then what they want, they...
In the Slovakian capital, Bratislava, European leaders are coming together to discuss Brexit and the future of Europe. They are trying to understand why citizens don't trust the EU anymore. A group of truck drivers, brought together by the Dutch trade union FNV, believe they have some answers.
Nu sunt surprins că muncitorii își pierd încrederea în Europa, deoarece chiar aici, sub nasul liderilor europeni, companiile din vest își fac cu căsuțe poștale și practică aceleași politici de aducere a forței de muncă ieftină din România, Bulgaria sau alte părți a Europei sau dincolo de continent, din Filipine, spre exemplu.
De mogelijkheid dat dit soort postbusconstructies gecreëerd kunnen worden binnen Europa, ja, dat geeft natuurlijk al aan dat er van alles mis is en dat er mensen tegen elkaar opgezet worden, want dat is natuurlijk het uiteindelijke gevolg.
Just a few kilometers from where the summit is to take place, we find the letterbox company used by the Dutch trucking company that was exploiting Cirillo and Joseph, two drivers from the Philippines.
You have been here in Bratislava, but never been here where the firm should be.
Yeah, that's true. That is the first time I see this. The office is nothing, only the address.
Op het opgegeven adres waar het transportbedrijf zou moeten zitten, hier zit helemaal niks. Je kan hier niet eens met een vrachtauto komen. We moeten hier met z'n allen iets aan doen.
By neglecting to enforce legislation that protects cross-border workers, the EU puts workers from the East and West in competition. The result is a race to the bottom in pay and working conditions. In the case of Cirillo and Joseph, their Dutch company used the letterbox construction to set up a smokescreen around human trafficking and exploitation.
Always little bit space in my truck. Always stay here. After work, stay in my truck. After that, can I give the new order, go, finish work, stay. In the weekend, always in the truck. I have no time.
We have no time, just like a prison. You stay always inside the truck, just like inside the jail.
Cirillo and Joseph lived for months in the cabins of their trucks, in terrible conditions and working for starvation wages. An investigation by the FNV brought the case to light.
I'm very sad, sir.
Okay, back to you.
So, some people who were not in favor from enforcement like to frame it like anecdotic stories, and this is how Europe looks like. I think this shouldn't be our Europe. And if we see about all you here in the room, if you get from your country where you come from, have to work here in Brussels, I think you have to get 200 stamps to get employed here. To do things like this, you buy a plane ticket for €1,000 for Filipino workers. You ground a letterbox company. Who cares? So we think we need strongly public-private cooperation in this topic. No way out for member states who do not want to enforce. And it's not the situation about East and West, because in the West, not even one country has enough budget and to work according to European rules to enforce the number of enforcements they need to do. So this is a European issue. So I think this is enough for the first.
Thank you very much indeed, Edwin. Social Europe stops at the border. So what do we need to do about it? I was very struck by your phrase about forcing national authorities to enforce, and that has become a role for you. Would the proposed new ELA actually be able to tackle that? You raised the issue, a number of you have raised the issue about the voluntary nature, for example, of inspections and so on. Does that need to be addressed if we're really going to have progress? And also very struck by your comment about we tend to think of this as an East-West problem, and that is the wrong way to view it. So thank you very much to all three of you. The challenge becomes very clear. I mean, in terms of going back to Erica's question, and Dana, perhaps I could start with you here, in terms of what are the gaps we need to tackle through ELA, what, in terms of those very practical examples you gave, where do you believe that without an authority like this, your job was made more difficult? Where do you believe it could really make the most difference? We'll come to whether the proposal fits that, but where could it help most to address those cases you gave us? Same question to you, Edwin, and then I'll come back to Erica to react. Dana.
I think in the national member states that have strong social partners and common institutions like Germany, it's necessary that these institutions also have access to information. For example, let's go back to the Dutch company. There is no institution no German institution going further than the German construction site, and also go to the German tax advisors and look at the data. But there is no institution going abroad, or it's difficult to go abroad and to see what's really happening. And we are not talking about East-West, we are talking about the Netherlands. So that's so, and it's more the role of the social partners or the common institutions should be more strong, or at least there should be the framework for enlarging the competences and the
But you're focused there very much on the information sharing side of things. For you, that is the biggest difficulty that you had, knowing and being able to access that information. That is a sort of exchange of information. Do you also believe that in practical terms, then using that information, an authority could have helped you to tackle the issues?
When you look at this Bulgarian case with the enforcement in Bulgaria, once we have this information and once we found out how it works, once we have a solicitor that goes and does the enforcement of this judicial claim for us, then the process is, of course, shortened. It's much faster, and then we are much more successful. But when you start once in one country, or you have some problems in one country, you need some information and some contact partner that has the overview on the national institutions and authorities, and that can connect you with them.
So very, very key once you have that, as you say, the whole thing accelerates and it's easier to tackle. Edwin, from your point of view, is access to information, better information sharing the key here? Are there other things where you faced real challenges in addressing these issues? And by the way, it's great to have with us also a couple of the other stars of that video. Thank you so much to all three of you for coming and joining us this afternoon. Edwin, in terms of the challenge that you face, what part of it could a new authority really help you with?
First of all, it's a question on priority for enforcement in member states, because what we see now, that for example, the European Commission starts infringement procedures against Germany and France for the minimum wages in road transport. And as far as I know, the Commission never started an infringement procedure against a member state who does not enforce social rules. So first of that, the priority, this should be monitored by the Commission. And then no way out from member state. Enforcement is not a matter of political priority. It should be a social European standard. And on sharing info, in the Netherlands, we try to go as far as we can in public-private cooperation between the enforcement authorities. And it's an enforcement tool, important tool. And I think in a European context, it's a big goal. And then also share the sharing of tactics. I think it's important in banning these symptoms. And to be very simple, what we need is a social Europol. Boots on the ground who go out to check companies, because in our reality we see companies who act like grasshoppers. They go in member state 1, get maybe caught, if the workers are lucky, go to member state 2 and act like grasshoppers. And this should stop. This is not why we have the free market in Europe.
Thank you very much indeed. Erica, I don't know whether, is that true that the Commission has never taken infringement proceedings for non-enforcement of social rules? I don't know whether you know the answer to that question. But in terms of the challenges, is there anything that you would add? And I'm just wondering here, listening to Edwin, is it, do you think, the case that national authorities have many of the tools, they're simply not always choosing to use them, or how effective are the tools that they already have to address these issues? So is this more a case, when we later talk about ELA and what it can do, of making sure they use those tools, or does ELA need to fill in some gaps in the tools that are available?
I guess we all agree what Dana and Edwin said, the developments as regards temporary agency work, bogus self-employment, trafficking. There are a lot of cases, a lot of evidence, but if I see it correctly, there is no clear diagnosis on the member state level how the law enforcement is really done and where the gaps are. I know Germany best, coming from Germany. In Germany, labor law enforcement is done by the customs, financial ministry, not at all related, analytically speaking, with the Ministry for Health and Safety, no labor affairs and social policies. So before you start, I'm also coming from the, let's say, public administration thinking, also efficiency, before you start creating a new body, you have to really know in more detail, maybe I overlook something, what is the diagnosis, what are the regulation gaps from a law perspective, what is the implementation issue, Dana gave an example, nothing is happening. So I would argue then, okay, go to the 2 or 3 member states involved in one of the cases you mentioned and strengthen the bodies there, and then we will see and follow up. I didn't hear strong arguments as regards the current proposals for the governance of an ELA, what a body with, let's say, 50 seconded national experts, or 70 or something like that, and 70 coming from the European Union, what they should do about, because informing each other, you can enforce that. Secondly, monitoring things, soft law, giving guidance, you can do already. The crucial issue is, you mentioned it, law enforcement. Social Europol was mentioned. Maybe there is a need for that, but I do not have yet, we do not have yet, the clear evidence where we could say, also in an institutional analysis, governance structure, okay, if we have this body with 150 staff members, wherever, this body will be able to change reality. And you rightly said it's about European social Europe, the elections, the citizens. Will we be able to convince them that reality for workers is changing? So that stays somehow vague, and we had all these nice bodies, EURES, undeclared work platform in here and so. So what did these bodies do over the last years, these 6 bodies who are now integrated in the upcoming ELA? I can't verify this in great detail.
So a more detailed mapping, really, of what we have, what they have done, and we come back then to your point, Erica, you raised the question about later on how they work together in the cases where they continue, in the cases where they are absorbed into the new authority, what difference will that make? Dana, Erica's suggesting there we don't have a clear enough picture yet of what it is we're trying to do. Would you agree with that? Or do you think on the basis of your very practical examples, we know what the problem is, and particularly in relation to national authorities and whether they have the tools that they need? What is your reaction to Erica's point?
Let's come back to the Dutch case again with these temporary agency work. So what we did was going to the national institutions and we told them there might be an abuse, but we don't know what to do. So then it ran from one institution to the other. We had this labor authority that gained the temporary allowance, the certificate, the temporary allowance, the certificate, and on the other hand there were the customs, and that needed to give the input to the custom authorities so that they can see it's not allowed, or it's not a company that is worth getting the certificate. But actually, what else could we do? We were not allowed to go to the.
Or what could the authority do in the future?
Yes.
Maybe?
It would have been necessary to get connected to the Dutch control authority so that they check whether this company, what this company do.
So I was going to ask you how effective cooperation is between national authorities now without an ELA, but actually we seem to be coming much more to an issue of cooperation within national authorities before we even get to the cross-border issue. Yes. So maybe now, question mark there, is there anything that a European authority can do to help in that area, or would that be overstepping its bounds? But Edwin, from your perspective, you talked about forcing the enforcers, as it were. Do you think the problem lies with a lack of tools at national level to do this, or an unwillingness to use them? And how do you see this question of operational cooperation between national authorities? Is it, as we're hearing, actually problems much more basic, it's at national level, first of all?
For sure, there's always a national level, because, as I said, enforcement does not stop at the border, there it starts. So in your case, it's not national because there is a cross-border element. And because the enforcement part of our social Europe never mapped out. All member states have different ways of enforcement, or maybe not enforcement. But if you map out a picture, you see that sometimes, maybe also in your case, there is no priority or even no enforcement department on, in your example, social security. In the Netherlands, we actually need to enforce the authorities to enforce the A1 system. So in this, there starts the national element. But in cases like this, the trade unions are not responsible. It's not our job to enforce the authorities, to enforce the rules to keep our Europe going on. No, it's Europe. And in the end, the Commission has to take the responsibility to let the member states enforce our Europe. And in cases like this, it's like member states throwing out the problem from one department to the other part. It's unbelievable. So I don't know if this was an answer, but...
We are here diagnosing the problem. You'll be relieved to hear more than providing the answers. I'll force my second panel to provide more of the answers here. But just in terms, and Erica, I heard you mutter there tripartite structure. One of the differences between this authority, as proposed at the moment, and others, is that it doesn't base itself on that formal structure. It more talks about an advisory group which would include social partners. You muttered that in response to what Edwin said. Why at that moment did you feel the need to use those words? What do we learn about the way other agencies work, and why they've gone down the road they have, what difference that might make? Thought on that from all of you, and then we'll open up to the floor.
Well, on a personal capacity, also coming from Eurofound being a tripartite agency, what Edwin said, I think social partners matter an awful lot on the workplace level, on the company level, on the sector level, and the state level, national agencies, authorities, ministries. So from an analytical point of view, I would say it's quite natural, maybe NGOs, quadripartite even. It has to be a joint effort to gain any progress in this regard. And as you said, Jackie, if I remember well, there is supposed to be a stakeholder group with the social partners.
Advisory group.
Yeah, and that's about a bit of wishy-washy soft thing, I would say. So you should be more firm. That's my personal view, so we have no Eurofound view about that yet. But you have to take the social partners on board to gain some progress there. Otherwise, it's an, how do you say, a lady without legs or something like that. So it's no enforcement body there. So yes, I guess governance structure, the right people at the right place with the capacity you need to have any progress there. Yes, I think so.
I don't know whether either of you would like to comment on that decision to go down the road of a, Erica described it, not me, as a wishy-washy advisory group rather than something more formalised. But did you want to add something on that, Dana, Edwin? Then I'll come out to all of you.
I think the point to integrate the social partners in this is a good idea, but what about the countries that have no strong social partners? It works that, you know, we have all these bilateral agreements with other like institutions like ours, but it works on bilateral agreements, but when we go and look to countries where there are no social partners or no strong social partners and no institutions like this, then there is an end.
Yeah. So, yep. Oh, Ivan, please, you have an idea. Go. And then I'll come to Edwin.
Okay. Yeah. The idea is we talk an awful lot in Europe about capacity building of social partners, especially in the so-called new member states, Eastern Europe, Southern Eastern Europe. Though that could be an angle, a policy topic, to say, okay, that's the proof of the pudding is in the eating. Let's build up social partner structures and give enforcement capacity there. Even, I mentioned NGOs in some countries, Romania, for example, we have functional substitutes for social partners. Even with them, you could start and go forward. So I would say, yes, use it as a challenge to build up something.
I hope we will hear in our next session when we have someone from the Commission with us, and I'm not trying to prejudge what he will say, but why the decision was taken not to go down the same structural route as your agency. But Edwin, in terms of the role of the social partners here.
Now, it's good to hear that we all don't want wishy-washy stuff, because on some part of the labour market it is wishy-washy, and that's the exact reason why we debate about this topic. And with the role of social partners, I meant like in analyzing the monster and simple fighting the monster. It's where this topic about. It's not about big dots on the horizon. Workers and good employers need enforcement. Everybody on the labor market knows who in the cycling peloton used doping. And we talk about doping years and years now. We know the bandits, so we have to talk about how get these doping users out of this peloton to have a fair game. Practical, this is where I see a role of trade unions. And in fact, if there is the political will to fight this monster, I see a clear role for the trade unions, not in wishy-washy stuff, but in practical fighting the monster. Europe needs a social Europol that shows that it's done with crime on the labour market.
Come back to what that social Europol, if you agree that's what's needed, might look like. I also want to come back on how effective operational cooperation is now. Cooperation between, we talked about this question of duplicating and risk of overlap, how effectively your agency and others coordinate and avoid that at the moment. But let's go out to the room and see if there are any questions or comments to what you have heard so far. Would anybody like to join in our discussion at this stage? Yes, please, and please do introduce yourself. Thank you.
Herzlichen Dank, Arndt Spahn.
Yes, thank you very much. I'm from the Effort Agricultural Union. I just want to support what my colleagues have said from Germany and the Netherlands. We really do need the European Labour Agency. We need pressure to be put on national structures We need to have enforcement for many different reasons. In many member states, we don't have independent enforcement institutions. They are often institutions which depend on the government, and we see that there are people who are working and are sending money home, even if it's only €3 per hour. If you look at Puglia in South Italian, for instance, 20,000 Bulgarian workers are working under unacceptable conditions. And then, strangely there, we have an attaché from Bulgaria trying to look after these people, whereas the Italian authorities don't seem to appear anywhere because the whole thing is sort of socially accepted and integrated. Now, it is starting to change, and we're very pleased to see it change it, but I think that is one specific example of what's happening to thousands of workers and how their situation can be changed. You need to have Italian and Bulgarian enforcement authorities working together, looking at how they can improve the situation, how they can force the other party using European legislation to deal with the issues and to be more independent. And I think we've got lots of examples of this in Spain, in Lithuania, in Poland. We've got migratory corridors where you have Polish workers working in Spain, and then they're being replaced by people from the Ukraine or Belarus. So we have lots and lots of examples, and we can make it very, very clear why we need a European labour authority with involvement of social partners, because the national governments won't do it on their own because they are affected by other interests.
Extent, from what I understand, bearing some fruit, but not enough and not fast enough. Other comments, questions to our panel at this stage? Anybody want to join in the discussion? Okay, I'll give you another opportunity in a little while. Erica, could I come to you on this question of, we heard there about some operational cooperation. How effective is it now? I mean, how big a hammer are we going to need to crack this particular nut? And how do you, agencies, you raise this issue of duplication, the risk of duplication, so on. How do you work together now, and how do you see that changing in terms of cooperation in the future once, assuming this proposal goes through, we have an ELA?
Well, honestly speaking, I do not have the full picture where the gaps of law enforcement are happening within member states and between member states, but we all know cases where there's a problem, and there are issues, was mentioned now in the agricultural sector. We know about the seasonal workers. We did some studies about that. So the scandalization, right, so in different sectors for different groups of workers is already visible and there for a long time. The only question seems to be, what is the right remedy to really improve the situation or get rid of bad practices? I only can say the social science-oriented agencies, CEDEFOP, OSHA, Eurofound, Training Foundation, but also Fundamental Rights Agency, probably could play a role because they are in human trafficking involved in some analysis. Eike Institute, Gender Institute, the same. We are ready, but it's a social science support we could deliver based on our surveys, data collection, looking at specific member states where the male practices are really, fates practices are really bad. But we do not have the magic stick to solve any issue. And of course, you need a mandate for that. And we are a commission body. Our founding regulation is under revision at the moment. So there is no, let's say, fourth or fifth policy topic, labor mobility, migration, where we are asked yet to focus on in the future. But in principle terms, I guess we were able or would be able with other agencies to do so.
And on that question of how you align and divide up, sort of clear division of labour between you, the other agencies, the new authority, how is that? Is it clear at the moment? or is there some duplication and overlap? And do you see a risk with a new authority of that happening? If there is, what are we going to do about it?
I think there's no risk. Our new Director General, Jos Korte, was asked recently in the Ample Committee if he thinks, being in charge of the 4 agencies, if he sees any task for the agencies to step into the issue. And he was more or less saying, not really at the moment, but also adding, OSHA, for example, they have health and safety inspectorates, they have focal points on the national level, but it's focused on health and safety issues. We have national correspondents who are supposed to report about working conditions, industrial relations, that are not labor lawyers, that are social scientists collecting data. So I do not know any network of one of the agencies which is strong in law enforcement, labor law issues, in these legal issues. So insofar, there would not be a negative interface or overlap. It's just a niche where there seems to be a need to do something. It's more the question how to do it properly, what are the instruments, what are the tools, member states or cross-member states or European or a mixture of that.
I don't know, Edwin, the extent to which in your work you already liaise with and work with these various EU agencies that already exist. Do you? And if you do, in terms of the joined-up thinking, you were appealing for it at national level. Are we succeeding? Have we got it now at EU level? And if we have or haven't, what impact do you think a new authority might have on that?
Now we operate specific in road transport. We have the European Control Route. It's a cooperation body between the European road transport enforcers. And where we see if they can take their role in authorities who committed to do the job, they do fantastic work. But over there we see it's a voluntary joined up to the ECR. So we see black spots on member states who are not active. And my analysis from now on, member states step out. And if I see what happened, they did some enforcement actions in these member states, and then the priority isn't there anymore. So that means that we need strong European guidance on there's no way out on cooperating. I think we need to build a new infrastructure on that.
Okay. Might look like in a moment, but Dana, on this question of really making sure that we are ensuring that all these different agencies continue to add real value, support you in the sort of work and the sort of issues that you're addressing, and how you see the authority fitting into that picture.
Difficult.
Difficult.
Difficult because we don't know enough? Or difficult because what makes it such a challenge?
I think the challenge is to see what the national institutions are and what needs to be regulated on the European institutions, because you have in some national countries you have probably a very good working system, or it just needs a small point to start a process that works. And in some other countries, it's, you don't know where to start, and you don't know how these informations, how the institutions are connected. And you need a very much more individual, adapted system to what to do. So you need a big framework that allows, on the one hand, freedom, and on the other hand, you need a framework that allows also to take strong actions, and that makes it difficult from my point of view.
Thank you. Just want to give the floor to Georgi Pirinski, MEP, who is the shadow rapporteur on this issue. Georgi, please.
Yes, thank you very much. I will be trying to sum up this at the end. And
tasks that you will have later on.
Yeah, and I will have to be watching out for 6:15 because I know that you'll be cutting me short. But what I wanted to perhaps examine a little bit more is actually what we have in this panel as the current situation. Because I think we've been touching on various aspects of the current situation But basically what is coming out that we don't know very well what the current situation is. And in the communication of the Commission, the explanatory memorandum, there are several challenges that are mentioned. Inadequate support and guidance for individuals and businesses regarding information on rights and obligations, insufficient access to sharing of information between national authorities, insufficient capacity of national authorities to organize cooperation, weak or absent mechanisms for joint border, cross-border enforcement. These, to my mind, sound a bit technocratic and more like the results of something which is deeper and really not trying to speak very long, but what came out in one of the statements that much of these practices have become socially accepted and integrated. So perhaps both people in the room and the panel would like to come back a little bit more and try to see what actually is the monster that you have been mentioning, and to what extent are there in place capacities to actually analyze and define what we have in front of us.
Then you're absolutely right. I think that hence the question I was trying to say about, is it that member states are not using the tools that they have, that they could use, or is it they don't have the tools? So what is it that this authority will need to do? Is it to highlight what tools are needed? Is it to force the enforcers, as Edwin put it right at the beginning? And all those issues that you mentioned, which, as you say, are in the communication, the examples that we've heard touch on many of them, but it goes back to Erica's point about that really complete picture. I mean, it does seem astonishing in a way that we have these gaps, and I mean, you exist to identify these sorts of challenges and problems. Why, Erica, why do we have such gaps? I mean, we're going back to basics. Can we really discuss, we're going to discuss in the next panel in more detail whether the authority can meet these challenges, but as you said, we don't really know what it is we need them to meet. Why is this so difficult? And in terms of analysing the current situation, what can we do about it?
Well, there is a data collection issue, very simply speaking. Access to registers, company registers, data in general terms are hardly available. You have to go on the workplace and company level. There's now, in the meantime, also a data protection issue. It is as with homeless people also, the data is very vague, it's very sensitive, and there is a lack in social statistics in this area as far as I know the matter. And if you want to change the game, I think it could be the task, let's say Eurostat. They are collecting member state level data collection to reinforce national statistical offices, for example, to try to collect data. How you do it, I do not know. We have the European semester since 2011 or so. Of course, the Commission could, so to say, enforce, impose, ask member states to build up data there, to do something about it, to tackle issues more strategically and with more firm effort. But it's building up some competence, I guess.
In some ways, it's about asking the right questions,
I think so.
or you don't get the data to give you the answers. Dana, you want...
I think from my practical experience, it's not that difficult to get the information from the Handelsregister, from the registers.
Okay, in some member states it is a problem.
Sometimes you have to pay, but sometimes it's okay to get the information, but the point starts when there is a difference between what is in the register and what's real. Then that's where the problem starts, because then you have the access to the official information, but when you're expecting that there's something going wrong, you need someone that looks. And then
that next step. I'll bring you in a moment, Edwin, but Agnes, I think, wanted to come in.
of course, illegal practices will not be registered in the registers. So, at least I don't think that companies are have their shadow bookkeeping also on record in the official records. But the thing is, I'd like to ask the question about. I read stories about the Belgian practice where the authorities working together with the social partners in the different sectors, and they more or less draw up a list of companies in which they go and look. I don't know about data protection because I don't know how this is, the drawing up of the list is being done, but I hear quite big numbers of fines by the Belgian labor inspectors, and not only fines but also collecting unpaid social contribution, etc., etc. So this would point to the situation that you need to get social partners involved in drawing up the list where we start. Of course, you have your data in general, which sectors are more or less prone to these illegal practices, but you even hear quite right-wing cabinet ministers of Belgium, of the Belgian government, saying we're earning money by doing this. So they more or less arrange a business model where the inspections is earning money, and I think the point Georgia was making, it's part of a business model. If we all know this, or not all, but the people involved know that, then a close cooperation indeed of the officials and the social partners involved could be perhaps a good way forward.
Which raises a question which I hope we'll come back to in our next session. When it comes to joint inspections, who can trigger them? And can, what is the role of the social partners? Can they trigger it? Can an individual member state refuse? But we'll come back to the detail of that later. But this broad principle, and I don't know, Edwin, whether you know about the Belgian situation and can confirm what Agnes is telling us, because she says she hears it anecdotally. Can you comment on that, but also on that broader issue?
Yeah, two things about the Belgian situation. I think the cases I know is a good example of public-private cooperation, trade, social partners and enforcement authorities. But the result of that, it's actually strong Belgian legislation, like something is quite quick, a social crime. Not paying the salary a worker should get, it's a crime. And then in the, what is the monster? I think it's clear. If companies use the free market, impose workers whatever they want, this is what we all agreed in Europe. But where we see that law breaches, it's not paying salary, it's a business model. But in my opinion, the most bad situations, the black examples, is social economic crime, where the example fit not in the statistics. I totally agree that the European statistics are bullshit, really. Because if we do case studies on the statistics, company A, they have the statistics, and then the national registers say on social contribution there are 10 workers. How come that we find 50 workers with the E1 social security number? So then it's, the monster is clear, it's fraud. Yeah. It's clear. So I think to start fighting this monster, let's try to use the best practices we all have, like the Belgium example, to start working. And if you do that, you give a political clear system signal to the cheaters in Europe, what the labor market and the fair employers really need, fair competition. And then learn from these best practices. And I think if we all, in whole Europe, we have the same law, like not paying social contributions or not paying, it's a crime. We will have the debate in the coming 4 years, but to say this was a success what we did because the labor market is most clean. In my daily job, we will never ban all the bandits. It's also not what we need, the goal need to be, but there has to be a balance in that abusing workers and do social economic crime is not a business model anymore. And now it's a business model. Getting into this building is more complicated than establish a fake company somewhere in Europe and enforce workers.
But Edwin, can I just follow up on that in terms of, and as we talk about, you talked about, I like your phrase about we will never ban all the bandits, but you talked about a social Europol and boots on the ground. We also know, and I'm sure we're going to hear more about this in the next session, concerns to ensure that whatever this new authority does, it does not displace the role, the autonomy of social partners, of national labour relations, and that circumstances are different in different countries. Can I just ask you, because I'm sure it's an issue we'll come back to, how, in your view, does the EU get that balance right between respecting very long-established and very well-entrenched principles of social partners working together, but has that teeth that you are really calling for? How do they get that balance? Just a quick thought on that, if you would.
First of all, it's the political signal the Commission sends. Europe, Juncker said last time, hey, Europe is not a jungle, it's a fair social market. It's not how I recognize the labor market. It's a jungle. It's a jungle. Everywhere you all live, 10 kilometers from where you live, we found cases like this. Road transport is not specific. So it's a jungle. And do we fight this jungle with words and open up a new office in Europe and fill it up with Commission staff or ELA staff to fill the office and to say, now we are going to fight this monster? Or will we practically do it and show practical examples where not only workers but also employers in Europe, we see, this is my Europe. And I think this is the most easiest thing Europe can do. Show a social face, not only talk the talk, but walk the walk. And I never saw it.
Okay. Thank you very much. A quick thought as we wrap up on that, but also can I ask each of you to identify? We've talked about a lot of issues ranging from mapping the problem and being absolutely clear what the current situation is, through to some of your calls for action, what you want to see this new authority do. For each of you, if you had to identify one priority, one thing that needs to be within the mandate of this new authority when it's finally agreed, what for each of you is the most important thing that it can do to help you, Dana, in your daily struggles, in your daily efforts to tackle some of those practical examples you gave us? What do you think is so, how do you see the role of Europe vis-à-vis the role of national authorities and your one priority above all else?
As I said in the beginning, it's the lack of information for social partners or joint institutions of the social partners. If you have the right to access, for example, the information systems and not go via the custom authorities or the labor authorities, we would have a direct influence and we would have a direct mandate to do something, and not would be, it would be more direct, not lost somewhere in the desk.
Thank you very much. Erica?
No, I think it would be about law enforcement, implementation of practices. Europol, social Europol sounds quite nice. But again, this issue is sharing the responsibility between member states, within member states and the European level. Not clear at all. Secondly, I think this issue, new social dialogue, was also a mandate now of the current Commission. You can build on the social partners, and where you don't have them, you should do something that they will emerge and go forward. Finally, it's always also about concrete qualitative analysis. This example we heard here in the plenary, collecting them. We are partially doing that, documenting fraudulent forms, fraudulent practices in different member states, not only to scandalize it, but to give guidance to policymakers how to change it. I think that are the core issues which should be done.
And when you talk about that sharing of responsibility, we'd like to come back in our next session, just to warn the panellists in front of us, to a question that Agnes raised at the beginning about sanctions and companies and the degree to which this authority should have teeth in the way that the banking authority, that analogy that Jean-Claude Juncker talked about and you've talked about as well. So we'll come back on those issues. But Edwin, for you, the overarching priority, the one thing that you want to see in the final version of this proposal, above all else, if you, with your daily work and your daily struggles, and thank you again for all of you for being here with us today, one thing they need to do to ensure this authority really does support you in that work that you're doing and deliver this social Europe that you have pleaded for so eloquently?
It's quite simple. If these companies who organize this monster read this piece, if they're scared, I'm happy.
And on that note, ladies and gentlemen, will you join me in thanking our panel very much indeed. Thank you to all three of you. You may return to the comfortable seats. Thank you very much. So, how do we tame the monster is the way I think I'm going to frame the challenge for our next session. So we have discussed the challenge. We have tried as best we can to identify the current situation, the problems, the diagnosis. We have heard that there's a lot of work still to be done there, but we've also begun to assess the degree to which the new authority could help to address those. Now we want to really drill down into the details of the European Commission's proposal to assess how well it is equipped, as it stands now, to meet those challenges that we've been discussing. What, if anything, our panel would like to see changed in order to make sure it can meet those challenges. How effectively, to go back to Agnes's opening question, how do we ensure that at the end of all this we have a serious and effective authority? So, very warm welcome. Let me introduce our panel. We have with us, and he's already poised for action, Denis Janton, who is head of the Unit for Free Movement of Workers, EURES, in the Directorate General for Employment, Social Affairs and Inclusion in the European Commission, man in the hot seat. So very warm welcome. Thank you for being with us, Denis. Colin Williams, who is Professor of Public Policy at Sheffield University Management School. On that side, we have Lena Carr, who is Confederal Secretary of the European Trade Union Confederation, and last but not least, Walter Gagaufczuk, who is a labour law expert working for the Austrian Chamber of Labour. Very warm welcome, same format as before, 7 to 8 minutes opening remarks each, and then we'll dive into the discussion with questions from me, and then I really do hope also from you, your questions and your comments again. Denis, man in the hot seat, please, over to you.
Thanks. Good afternoon. So this is a metaphor because my seat is okay, I can tell you. Thanks. Thanks to the S&D Group for this invitation, and thanks to the first panelists and what they say. They provided very concrete examples, so I was carefully listening to what you said. And also thanks for this information. Maybe if I can, before introducing our proposal, the Commission proposal, if I could come back to what was said about infringements and that the Commission has not launched. This is not true, I'm afraid. We are very transparent on that. Every year we publish a scoreboard where we list all the infringements that the Commission has taken in the year, and yes, there are some areas where the Commission is more active than others, and this is the case for environment, transport, taxation, but you know, the areas relevant to our policy field, social security schemes, and the free movement of workers, working rights and conditions, they are quite high as well on the Commission agenda. Okay, but once again, many thanks for all what you have said. In this first session, I listened carefully. So this is for me the possibility to present you the Commission proposal. Maybe I will, since I really want to stick to the 7-8 minutes, I would like, this is a standard presentation, but I will go a bit quickly. I would like to basically to say two things. Why did the Commission table that proposal? And I would like to present briefly the contour of this proposal, whether or not it meets the challenges that you have been discussing in the first session. So you know, there is this statement by President Juncker, but why did he make this statement? You may know that in the past 3 or 4 years, the Commission, and together with the legislative authority, the European Parliament and the Council, has been very active in the field of labour mobility. So we have proposed, and then the legislative authority has adopted enforcement directives in the field of posting and in the field of free movement of workers. This happened in 2014. Then the European Parliament and the Council adopted a reform of the EURES program instrument. And then the Commission proposed the review of the posting directive, the model directive, the directive that was adopted in '96, and this was just finalized thanks to the work of this House as well, and there is somebody here who did a lot about that. We have as well proposed a review of the 883 regulation. This is about the coordination of social security rules. So you see the rules on the EU rules on labor mobility, a lot has been reviewed, done in the past 3 or 4 years. Then there was the proclamation of the European Social Pillar as well, which contains clear indication on that as well. And to complete this work, the Commission proposed the so-called Social Fairness Package on the 13th of March 2018, with a proposal to establish the European labour mobility. And one of the reasons why we have done together with the Council and the European Parliament and many other stakeholders all this intense work over the past few years is that, yes, labour mobility in the EU is a reality and has become even a deeper reality. And the data are quite obvious and telling in a way. So you see the number of mobile workers, those workers who made sometimes a difficult choice to leave their country and to work in another country, has almost doubled in 10 years, and the same trend for posted workers as well. And we have the same trends as well in the numbers of commuters, in the numbers of workers active in the road transport sector. We see the same trend. So this is why we believe that indeed we have many schemes in place. We have rules, we have programs, but we thought that it was time to move up a gear. This is why the Commission proposed this authority with the 3 following objectives. So you have easier access to information. We need to offer the possibility to strengthen the cooperation between the different actors and above all, national authorities, and the possibility to provide some concrete action, concrete output results through mediation. So this is the 3 axes or 3 objectives of the authority. And these objectives, they are broken down in 7 different tasks. So here, I will not go through this. This is already what I said. So these 3 objectives, information, cooperation, mediation, they are broken down into 7 different tasks, specific tasks. The first one is to facilitate access to information. The second one, to facilitate cooperation and exchange of information between national authorities. And the Commission proposed to do that, among other things, through national liaison officers. And by the way, we got some inspiration from Europol. So I heard about the social Europol, but this is a concrete example. The third task is about those concerted and joint inspections. And we will come back to that, I'm sure. The 7th task yes, this is something that we are already doing, but we believe we need to do more. It's not an easy one, so it's carry out analysis and risk assessment. This is to increase our knowledge of the trends of what is happening on the ground. And the fifth task is to support capacity building to national authorities. The 6 and the 7, these belong to the third objective. So this is about mediation and facilitating cooperation between relevant stakeholders for cross-border labor market disruptions. So these are the 7 wonders of the world, we say like this in English, that will be carried out by the European Labour Authority. Of course, what we propose is an agency. You will find there is a managing board, there will be an executive director, but as well something new and which is not foreseen in the common approach. This is something that was discussed between the Parliament, the Commission and the Council 10 years ago on agencies. So we thought that given the specific areas of intervention, this body should give the possibility for important actors such as the social partners to have their say, and this will be done through their participation in the stakeholder group. So this is something new that other agencies do not have. And what we propose is not something small. We are well aware of that. It's something at cruising speed of a body of 144 agents and with a budget of 51 million. So this is where we are. We have a very ambitious timetable, which is shared by this House. This is very good news. We are closely already, we have started to work with the rapporteur and the shadow rapporteurs. We had a meeting this morning. We have already started the work with the Council and other institutions as well. So the idea is to have already an agreement by the end of this year or maybe beginning of next year. And obviously the European Labour Authority will not be fully operational in 1 day or 3 months. It will take some time, but we hope to be in a position to start the work here in Brussels. This is how it usually happens as from 2019, so next year. Voila, so yes, I more or less managed to keep my time, but of course I'm happy to take part in the discussion.
Thank you very much indeed, Denis, and I like your description of the 7 wonders of the world. Please do come back and join me rather than sitting so far away for the discussion. I will come back and ask our panel later about where they think the focus should be in terms of tasks. Would they agree with those 7 wonders? And thank you for explaining the thinking behind it. Time to move up a gear, you said. That was the decision. We will analyse the degree to which this will really achieve that goal, I hope, during our discussion. But Colin, Professor Colin Williams, your opening thoughts, if you would, please.
Okay, thank you very much. I'll highlight what I think is one major strength of ALA, 4 concerns and 3 ways forward. So the one major strength, I think the real value added of ALA is that it brings together overlapping issues related to what I will call labour abuse and seeking to protect workers' rights in a much more joined-up manner than has been the case in the past. That's the one major strength, so it moves towards a more holistic treatment of those issues. The 4 concerns. The first concern is that ALA underemphasises the real value of national capacity building. The Commission proposal heavily focuses upon cross-border enforcement and, in particular, joint inspections. There's a real danger of losing sight of the very valuable role that ALA could play as a coordination mechanism for mutual learning between member states and improving knowledge on what I will again call tackling labour abuse. Building national capacity to protect workers' rights is a very important function. Now, it may be said that Article 12 in the proposal covers this. It doesn't. There's no mention, for example, which may be for political reasons, of improving knowledge. Not one mention. Second concern, there's little focus upon preventing labour abuse. And there's been little discussion this afternoon about this as well. The legislative proposal, again, focuses on enforcement and inspections. Now, just think about what that is. That is dealing with labour abuses after they've already happened. That's what you do when you enforce and you inspect. It's not preventing them from happening. And that is an old-fashioned approach. And I will use those words. A more preventative approach towards labour abuse is needed. All of the academic evidence for 20 years asserts this. And ALA needs to shift from an enforcement approach and away from social Europol towards a compliance approach. And if anyone can think of a phrase for in health services when you adopt a preventative approach rather than a curative approach, then perhaps we can replace that phrase, social Europol, with that phrase, please. Third concern, there's a lot of focus upon undeclared work. If we introduce the proposal as it's written, there will no longer be any group focusing upon undeclared work. We will be back to where we were before 2016, when the platform tackling undeclared work was established. Now, for me, that's strange. I don't profess to understand the politics which takes place in Brussels. All I know is that when I read the stakeholder consultation synopsis report, it very clearly and explicitly states that the majority of stakeholders agreed that ALA should have a coordinating role and not substitute for already existing organisations. There is no reduced political priority, as far as I'm aware, to tackle undeclared work in the EU, so there's no reason to let undeclared work be subsumed as an issue and disappear into some more generic thing. My fourth and final concern is that ALA focuses upon tackling only one very small segment of undeclared work. The stated aim of ALA, as Denis pointed out, is to support member states in matters relating to cross-border labour mobility. Well, only a maximum of 5% of undeclared work is cross-border. Indeed, a forthcoming platform report will actually show that only 2.8% of all undeclared work is cross-border. So, ways forward. It's a summary. First, we need greater emphasis is needed in the proposal on building national capacity to protect workers' rights and tackle labour abuse, words not seen in the proposal, including the improvement of knowledge on these issues. Secondly, ALA needs to shift away from what's been discussed today and is in the proposal, an enforcement approach, and it needs to move towards a compliance approach with much more emphasis on preventing labour abuse. Third, and as you might expect, why kill the European platform tackling undeclared work? Why not embed the work of the platform into ALA? What sort of parliament repeals decisions taken within its own parliamentary term of office? As I say, I don't understand Brussels. How can we do this? How can we embed it? Well, perhaps, I might naively say, move the Commission Secretariat responsible for the platform tackling undeclared work into ALA. The platform Secretariat can then be the coordinators within ALA to merge aspects of the current platform's work programme with other overlapping groups, and in so doing it can achieve certain efficiency savings as is desired. But if the platform, if the decision really is and ends up as being that you should repeal the platform decision taken within this Parliament, then at least explicitly name in Article 17, paragraph 2, that a working group or some expert group on undeclared work is retained. So my argument is we should be embedding the success of the platform into ALA and building on the valuable work it's been doing. The current proposal just doesn't do that. Thank you.
Thank you very much indeed, Colin. So very clear diagnosis there of the good and the bad. And the ugly, I think, you would say, certainly in terms of the platform. We'll come back and discuss all of those issues a bit later. Just to mention, we managed there, but for all the future interventions from here, if you could all use your microphone on your left-hand side, we're having some technical issues with the right-hand side. So we'll try and all stay leftwards in terms of our microphone use. I don't understand the technicalities, but that's what I've been asked to pass on. So Lena Carr, who I mentioned earlier, Confederal Secretary of the European Trade Union Confederation. So a mixed report card there from Colin. One very strong positive, but quite a number of concerns. What is your assessment of the situation?
Thank you very much for the invitation, and thank you for giving us the voice in this room. And it seems to me it's a particularly appropriate room. It seems to be left-leaning. So. So what do we in the European Trade Union Confederation or in the trade union movement think of the proposal? First of all, we really welcome that finally we are talking about something that we've been asking for years, for many, many years. But this is about how far it sort of goes in terms of really positive emotions about it. Because when we read the regulation, there isn't much there for us. There is the executive director, there is the board that will govern the authority, and then we have this stakeholder group. But what is the stakeholder group? It's 6. Yes, you heard me right. 6 European-level social partners. That's it. And we are talking about European Labour Authority that is supposed to deal with cross-border mobility issues, workers' rights, social fraud, hopefully also letterbox companies. And the stakeholders have 3 + 3 voices to try to influence the work of the Labour Authority. This is really poor. And we will definitely put our own proposal forward. We are working on it. We are really thinking how to improve this situation. What we have seen, I mean, the previous panel talked about the monster. What is the monster? What is it that we are dealing with? I think the more I really sort of dig into this issue, the more I'm seeing that, yes, one thing is trying to enforce the rules. One thing is to strengthen the existing European level rules, and we had a success in the terms of posting of workers directive, but at the same time we know that there is that the decision, the vote from TRAN committee undermines what we achieved in the Posting of Workers Directive. So what kind of legislation are we creating that then we have the authority to enforce? But what seems to me more and more what we are actually fighting with is the, I would call it fraudulent business models in Europe. The free movement of services, the free movement of capital is pushed so hard. We have to give the companies all freedoms that they ask for. And then we do not deal with the bordering illegal business practices that are used to avoid tax, to undercut wages, to undercut working conditions, and make workers to work in absolutely appalling conditions. So this is the approach, not the enforcement, but the compliance. So let's have good rules, and let's make sure that any company that considers not to play by the rules, this is made really difficult and really hard. But at the same time, like Agnes started, that we refer to the member state that we know best. So I refer to a member state that I know best. And in that member state, the labor inspectorate tells me that, oh, we are partners to our companies. But how can a partner enforce a fine on a partner? And then I look at the legislation that exists, and the fines they're nothing. They are not going to deter any company, anyone thinking of breaking the rules. So what can we do there? Is there a role for ELA there? There are many concerns, not only letterbox companies, but also the practices that the temporary employment agencies use. We have issues with the concerns over social security rules and how the rules are bypassed and what is done. And then we have the name, the European Labour Authority. But when we look at what is on the table, it's not an authority because it has no power. It coordinates. It exchanges information. It supports. But it has nothing. Because when you look at the banking authority, for example, there are very clearly in the regulation, Article 17, for example, says it's all about breach of the union law. Article 35 is the collection of information. And there are very clear rules, enforceable rules, how we can do it. Look at the enforcement of the consumers' protection laws. Article 9 on minimum powers of competent authorities. We have examples. So we should model, we should have much stronger labor authority. Inspections, voluntary. Why do we have them at all then? If you give immediately the possibility for anyone to back out from the inspections. It means that if we need these joint inspections, if we need to get across the border when it comes to enforcement, then we cannot also then open the door with the other hand and say, oh, here you are, you can walk out, you don't have to really participate. What is the sense of it? And also, the current proposal says that who can trigger the joint inspections are only the member state authorities. But the trade unions, the social partners are the ones, the trade unions on the workplace, on the ground, the workers experience the abuse. They see how the rules are being avoided and broken. And we don't give them the voice. We give them a sort of roundabout voice through a national authorities, maybe, yes, then somehow we can sort of get to the European level. And we come back to the governance, the stakeholder group. We talk about cross-border, European-wide issues, and we do not give access to national-level social partners. I think I'll stop here.
Thank you very much. Indeed, Lena, you have raised many, many issues, some of which very strongly echoing and endorsing what Colin was saying in terms of compliance and prevention and so on, raising those questions about, you know, why are we calling it an authority if it doesn't have authority, to put it very simply. Lots to come back on, and this question, which we touched on before, of joint inspections. But let us complete the picture before we begin to discuss all those issues. And Walter, say you, I know, working on these issues for the Austrian Chamber of Commerce. I just moved you right across the world, from Austria to Australia. The Chamber of Labour there. Over to you for your opening thoughts. And have you managed to find your presentation, or do we need... Well done.
Yes,
thank
you very much.
Self-starting. Great, thank you very much.
So I am the last speaker, and I have not much new, no. So I hope, but I have to repeat some points. We've heard already that on the one side that there's an imbalance. On the one side, we have companies that have the possibility to act on the EU in the European Union in principle without any obstacles. And on the other side, we have national authorities whose power are limited to the borders and to their own national territory. So there's an imbalance, and so I think we need something, an authority or agency or however you will call it, on a European level. I don't know if this European Labour Authority will solve all these problems that arise on the cross-border dimension. So I'm thinking about the letterbox companies on one side. I'm thinking about the fraud of portable documents, A1 documents, or the problem with ignoring the Posting of Workers Directive. So I don't know if this is a solution, but I'm convinced that this will be a step forward. Yes, and yes, I tried. I will talk about two issues. The first issue is I tried to compare. To compare the task of the European Labour Authority and the European Bank Authority. And here you can see Article 5 of the proposal for the regulation. This is the task of the European Labour Authority. And then the next slide, you have the slide in your documents. You can see the competences of the European Banking Authority, and I will switch to the third slide. Then we can compare these two tasks or these two authorities. And if you look at the authorities of the task of the European Labour Authority, you will read that this authority will facilitate the access to information, that it will facilitate the cooperation and the exchange of information, that it will coordinate and support concerted and joint inspection, carry out analysis, support member states, and mediate in disputes. That means the task, all in all, is very supportive of this authority. Looking at the European Bank Authority, the task is to develop technical standards, to issue guidelines and recommendations, to take individual decisions, to issue opinions, collect necessary information, provide a database, etc. So this is not just supportive. It's supportive, of course, but it's also setting standards. It's a very big issue for the banking authority, and supervising is also a big issue for the European Banking Authority. So my idea was how can we enhance the enforcement powers of the European Labour Authority? Maybe first that it is possible for the Labour Authority to issue recommendations and standards. especially regarding cooperation, exchange of information between national authorities. Or regarding provisions of mobility-related services to citizens and companies. And second, and that's from my point of view, it's the most important, is the possibility to take individual decisions in connection with the settlement of disagreements or disputes between competent authorities. Because of the one side, the European Labour Authority can support member states with capacity building, but on the other side, it has not the power to settle agreement by a binding way. That's not a balance for me. Or issue opinions on EU law regarding cross-border situations. And if you look at the European Bank Authority, Article 19, here you can see that the power or the task of the European Bank Authority is not just to be a mediator. It can assist the national authorities. It can set the time limit, but it can go even further. It can, if the competent authorities fail to reach an agreement, the bank authority can take a decision with binding effects to the competent authority concerned. And it can even go further, yes, when this competent authority of the national authority does not comply with this decision of the bank authority, it can also make an individual decision addressed to the final institution itself. So this has much more power, and maybe this would be a teeth for the European Labour Office if this has also the possibility to take decisions with binding powers. My last point is the European Labour Agency and social partners. If you look at the proposal, there is the social partners are part of the stakeholder group. They will meet twice a year. This stakeholder group is chaired by the executive director, and this stakeholder group may submit opinions and advice. Nothing more, and I think that's not very much. Some may say it's poor, and so my opinion was, what can be a possible role for the stakeholder group? And I have here some proposals that this stakeholder group is chaired by itself, maybe 2 years from the worker side or 2 years from the employer side, that there is a clear right to get information at the meeting, or to have the right to get information on inquiry, a part of the meeting, or right to get information, a part of the meeting in special cases, for instance, a work program of the management board, information of the analysis, etc., etc. I know in practice it will get this information, but why does this not is part of the proposal? Maybe there's a hearing of the nominated executive director before appointment by the stakeholder group, or the management board has to coordinate the work program with the stakeholder group, or go even further that two social partners are members of the management board, or they have the right to take part in working groups, expert panels, or mediation board. I don't think that these proposals go very far. I think these are moderate proposals for the role of the social partners and the stakeholder group. And yes, I think there is something that has to be changed within the proposal. Thank you.
Thank you very much indeed. Thank you to you, and thank you to all of you for a very detailed diagnosis of what you think is right. And I'd say there is that broad endorsement that, as you said, Lena, this is something you've been waiting for years, but a number of concerns. So let's dive into those concerns, and I'll try and take them one by one. Denis, perhaps could you, this point and where Walter was talking there about the advisory group and what it could and couldn't do, but a much more fundamental concern. Lena said, there's not much in it for us. It's poor, really poor, was the phrase she used. Why have you not opted for the tripartite structure, and how do you answer the concerns of those who believe that this simply does not give social partners the role that they need to contribute to making sure this authority really delivers? Can you explain the thinking behind the approach that you've taken and your reactions to what's been said about that?
Thank you. Thanks for the questions, and thanks for the comments. On this specific topic, so obviously there is a framework. The framework is what was agreed, discussed and agreed between the three institutions 10 years ago, a bit less, 7 or 8 years ago, when those three institutions decided to agree on what we call a common approach for every future bodies of the kind, agencies. And what was agreed in that framework is to have a certain type of governance, and the governance made of a management board, executive director, and so on. So it's difficult when you have made that commitment to table a proposal which does not fully meet what was agreed a couple of years ago. But still, the Commission, and this is something maybe I should have said in my introduction, before tabling this proposal, had a public consultation. So we consulted the public, but we had as well a targeted consultation with all the different bodies, committees that we have in this field, in the area of labor mobility and social security as well. We know very well that social partners are critical actors. In some member states, they even have a more important role than others. There is no one-size-fits-all approach. But they are critical actors, and we wanted them to be on board somewhere, while respecting at the same time what was agreed with the legislative authority on future forthcoming agencies. So we propose, obviously, a management board, we propose an executive director, but in addition to that, we propose a stakeholder groups. And this is Article, I think, 24. And then what I would recommend you to do is to read this article together with Article 21 on the management board, because there you will see a kind of parallelism. For instance, we say that the stakeholder group should meet at least twice. We have the same for the management board. So I don't know, this would be a decision to be taken by the management board and the executive director, but how they will plan the meetings, I don't think that, there will be one meeting of the management board in January and then 3 months later the stakeholder group. I think there should be kind of proximity so as to offer a good synergy between those two different sub-bodies. So this is the context. And I think that it is useful to recall that. This explains mainly why the Commission did not propose a tripartite agency, but still proposed something allowing to have social partners on board, because, yes, we believe that they are critical actors in this area.
Lena, if I could come back to you, because you talked about this the most, your reaction to that, but also on the other side of the coin, because you've made your concerns clear about this approach. On the other side of the coin, I know you also have concerns about making sure that the ELA doesn't interfere in the autonomy of social partners and national labour relations. And how do you see getting that balance right as well? So we await your proposal on how you think the social partners should be involved, but on the other side of the coin, where do we make sure that ELA doesn't encroach where you feel it shouldn't?
I mean, yes, clearly, I think there is as we see it, lots of room of improvement on the stakeholder group. But to address your other question about the other side of the coin and how to make sure that ELA does not encroach on the territory of social partners. when we have an example in the Posting of Workers Directive of a clause which very clearly stipulates that whatever is done, whatever happens, it cannot interfere with social partners' autonomy or fundamental rights to negotiate collective agreements and take collective actions.
So you feel the safeguard is there?
Well, no, that's in the Posting of Workers Directive.
Right, so we need the same safeguard here.
But we can bring the same safeguard into the regulation for the ELA. To make sure that this is very clearly stipulated, because when the proposed regulation came out, then we had lots of our members being very concerned about this. What does large-scale labor market disturbances mean? There were lots of people saying that, oh, but that can mean that we can't have a strike anymore. So there is kind of, that was the first reaction. So we have to make it absolutely clear, absolutely sure that whatever the agency is going to do, it will not limit in any way the right to collective bargaining or interfere with fundamental rights.
Anybody want to add anything on that before we move to some of the other points you've raised? No? Okay. Coming to the question of there's been lots of phrases used. Social Europol, we had a challenge of the use of that phrase earlier, but Lena said it's not an authority because it has no power. Walter, you talked about binding powers in this area, and I just wanted to quote Jean-Claude Juncker when, as well as the quote we've seen about why what the agency would exist to do, the authority would exist. He said, it seems absurd to have a banking authority to police banking standards, but no common labour authority for our single market. So in terms, and perhaps, Denis, I'll come to you first because it's a point that many of them made in different ways. Agnes said it needs to have a proper mandate. Do you think you have been ambitious enough in terms of what this authority can and can't do? Because we've heard quite a lot of suggestions that without teeth, then it simply can't really deliver, but it certainly can't deliver on prevention. And I'll come back to the task, but that compliance issue that both Colin and Lena talked about a lot. I mean, is it fair to compare the ELA and the EBA, as Jean-Claude Juncker did, and as our speakers have, or do you think that is a false analogy?
Thank you. Here again, I think I need to recall the context, the context in which the EU operates. So this is an area of shared responsibilities. And there are rules which are national, there are rules that are European, and they are transposed into the national legal system. So, I mean, the subsidiarity here is a key word, and what we have tabled, we believe, fully respects this, and this was taken very seriously when drafting the proposal. So is this an authority, or is this a new body? We believe that it is an authority in the three different axes or objectives that this authority has: information, cooperation, mediation. We believe that it should serve as a center of expertise. We want this authority to provide the best information possible to the citizens, to the business, and to the different national authorities as well. We want this body to be a center of expertise through having the best people on board. You know, we will talk maybe about these national liaison officers.
Yeah.
And we hope that their expertise and the action that they will implement will help solving many issues, and the same for mediation. So we think that what the outputs of this new body will be binding in a way, not binding in the legal sense, but have a kind of authoritative statement, or I don't know how to say in English, But in French, we would say that ces contributions feront autorité. This is what I would say in French. So this is why we believe that it qualifies as an authority, given the context in which it operates.
Thank you. Walter, you talked about that binding power. Denise saying there, well, not binding legally, but binding, I'm not sure, I'm trying to think of a translation, but I can't quite come to one. Do you accept what he's saying in terms of the subsidiarity issue here, that you drew the comparison, as did Jean-Claude Juncker, between the ELA and the EBA, but he said, well, in this area, we simply don't have the competence for that. So what we've done, we believe, respects the subsidiarity, but does give it that authority that it needs. Would you accept that at all, or do you think that's not a valid argument?
Yes, first of all, Jean-Claude Juncker, who mentioned the European Banking Authority, that was the starting point for me to look at and to compare these two authorities. For me, it was very clear that there is a great difference. That on the one side, there's just the possibility to mediate, and on the other side, there's a possibility to make a solution with binding powers. But I'm not convinced with this argument of subsidiarity, because how can we solve this problem? What other ways are here to solve these problems? This problem can only be solved on a European level. So for me, this is in the competence of the European Union, and the competence of the national authorities is not far enough to solve this problem.
So if you take your definition of subsidiarity, do it at the most appropriate level, your suggestion respects that principle, you're saying? Yeah, because it can't be done
at
a lower level. Okay, Colin, your reaction in terms of, and you talked a lot about compliance, about prevention, and just in terms of how you achieve that and where the focus should be. Obviously, you talked about capacity building and so on, but just staying with this question of teeth for the moment, how important do you think that is, and do you think we do have an issue here, a circle that needs to be squared relating to subsidiarity and the EU doing what it can within its powers?
Yeah, first of all, on teeth. Any authority needs teeth. You engage in education, awareness, raising to begin with perhaps those who are unintentionally non-compliant. You may provide some incentives for them to be compliant after that, but you need teeth at the end of the day if all else fails to ensure compliance. So any authority needs that. And I've been sitting here reflecting, why have these teeth been chosen for the European Labour Authority? And the teeth which have been chosen are cross-border enforcement and joint inspections. On the whole, they're the teeth which have been selected. It's the teeth this new body will bear. So what's it trying to achieve by doing that? And in the proposal, where's the evidence base? Perhaps you could talk a little bit about it to me, where the proposals have come from for the particular type of joint inspections and where they should lie and who the responsibility should be with. Because there is an evidence base out there about what works for joint inspections. The Benelux countries have been doing it. The Nordic nations have been cooperating. So to what extent has that evidence base been drawn upon in coming to the proposals about this is the best model for joint inspections and not others?
And staying with that question, because in the interest of time, let's follow up on that. In terms of the joint inspections, and you say they're the teeth that have been selected, how important, I mean, we've already talked about if they're voluntary, why have them, Alina said, because it's too easy. Who do you think should be able to trigger them? Should the social partners have that, or we go back to their role in all of this? Who and should individual member states be able to refuse to take part? How do we get that right, do you think?
Right. This asks a question, which I would put in another way. Teeth are the last resort. The last resort you introduce in only the most extreme cases where businesses will not be compliant by using all other means. And by choosing to bare these teeth and put the focus on these teeth, what has happened is that all of those other earlier stages in the process and what needs to happen in those earlier stages of ensuring compliance have been pushed into the background. And we, sitting here, are doing exactly the same thing again. We're only talking about the teeth rather than all of these other stages. And what of those other stages, what components need to be put in the proposal?
Thank you. So, Lena, too much focus on the inspections question, and it's obscuring what has to happen first. That's Colin's argument. But in terms of those teeth, and I'll accept that you say we're doing it the wrong way round, but it is an issue that's got a lot of traction. And you said earlier in relation to that, if they're voluntary, why have them? How do we make it work? Who should be able to trigger them? And you know, this subsidiarity argument, would you agree with Walter? Actually, he's saying, I don't accept it because I think this is subsidiarity because this is stuff that Ella has to do.
Well, subsidiarity issue, we are dealing with European labour laws. We are dealing with mobility. And dealing with labour mobility has never been, the subsidiarity has never been a problem there. So why do we have the subsidiarity problem right now for the authority that is supposed to deal with precisely these European issues? When it comes to who should be able to trigger the inspections, in our view, definitely the social partners at national level should be able to trigger them. Because as I said before, the social partners, the trade unions are there on the ground. They are the first to see the social fraud. They are first to see where the problems are. Or like in the previous panel, my colleague from Netherlands said that why do trade unions have to enforce the enforcers to take action?
Thank you very much. Denis, if I could come back just because it's been very much challenged. Lena's saying that, look, we're talking about free movement. We're talking about the cross-border element here. So if we're talking about the cross-border element, then why is the subsidiarity? And we know in the social area, obviously there is a limitation, but not here, because this is about free movement and crossing borders. So just if you could pick up on that, and this question about joint inspection and who triggers them, because that has, even if Colin says we're focusing on the wrong thing, Agnes said in her opening remarks, this shouldn't be voluntary, and that question of who can trigger them is generating a lot of debate.
Thank you. About the first issue, the first point, so subsidiarity. Why do you bother about subsidiarity? This is about cross-border mobility, so this is your area of responsibility. So why bother with subsidiarity? Okay, fair question. You may remember that in that very area, in 2016, the Commission presented a review of the posting directive, the directive that was adopted in '96. And then it took a couple of months, and we received 11 yellow cards from national parliaments, precisely for subsidiarity reasons. Okay, and of course we are not afraid of that, and they have the right to do to adopt such opinions, and we replied to all of them, and we found, we believe, convincing arguments to reply to them, and we kept the proposal. And now the proposal, with the help of this House, and in particular Mrs. Jongeres, was adopted early in the Parliament, at least early this week. So yes, subsidiarity is an issue that matters a lot to us, including in this field. And we had to be cautious and to assess it properly. And once again, what we have proposed, we believe fully respects. The good news, yes. And this is since the entry into force of the Lisbon Treaty, so it's a bit technical. There is this consultation of national parliaments for each new legislative proposal. So this is a legislative proposal. It was sent to the national parliament. They have 2 months to react, and we have received 7 opinions, and only 2 of them are qualified. So we will not get a yellow card on this. So this shows in a way that we have done our work properly as well. So we care about subsidiarity, including in those areas of cross-border actions. And the second question is about concerted and joint inspection. This is something new. If you go through the 7 wonders of the world, some of them, they are entirely new. This is one. Some others, they are less new. We have already some good practices. Yes, this is new, and precisely knowing what is happening on the ground, having listened to our stakeholders, social partners, obviously, but other stakeholders during the public and targeted consultation, this is the best proposal we could table. We see. I mean, at this stage, obviously, the ball is in the camp of the legislator, but our ears are still open.
Thank you. Colin, quick one if you would, because I want to also ask Denis, before I go out to the room, about your platform concerns and your national capacity concerns, but you wanted to react to what you just
very
said.
quickly on the inspections and who should do inspections. And this notion of who should trigger it, I mean, you just need to think on a member state level. On a member state level, how do you trigger whether an inspection should take place? Well, you identify whether it's a risky business. How do you identify whether it's a risky business? Either you use a risk management system, such as a database, and you have risk assessment criteria, or you receive hotline whistleblower reports from either your own hotlines or from social partner hotlines.
Thank you. So,
I mean, just to sort of a little bit to enlarge the debate is just, yes, we've been talking about the joint inspections, but from trade union point of view, this is just one element. And yes, we have made our points. But what we are actually asking in our position paper, which was available on the desk, is that the national trade unions should be able to ask ELA to help social partners to pursue cases across border, including unpaid wages, breach of employment rights, and tactical bankruptcies, to also assist to recover workers' financial entitlements in cases of cross-border insolvencies. So we are asking, actually, the concentration is not on the inspections, but the concentration is elsewhere. Yeah. The concentration is actually what the authority should do and what it should assist the social partners in dealing with cross-border problems.
Thank you. Just before I come out to all of you, 2 words, if you would, please, particularly on this concern, nay, I would say anger, that I sense from Colin, that this platform on undeclared work, he feels, why are you killing it when it was created during this legislative cycle, and can you not find another way of doing it? Can you address that? And then I'm coming out to all of you.
Thanks for the audience. So the Commission has done a lot of work on undeclared work, and I mentioned at the very beginning of my intervention that there have been a lot of activities in the field of labour mobility, and the setting up of this platform is one of them. I have not mentioned it, I forgot it, but yes, the Commission proposed, and with the support of this House, got an agreement on a decision setting up a platform tackling undeclared work. So this decision, I think, was adopted in 2016, in March or April, in the spring, and the platform became really operational in 2000, and already started its work in 2016, but the first year was 2017, and now it continues its work. So why does the Commission propose, and this is one of the articles, to repeal this decision? Of course, and this needs to be very clear, the Commission will not give up the work on undeclared work. I will repeat, the Commission will not give up the work on undeclared work. There will be still discussions and interactions with the member states in the framework of the European semester. As you know, the Commission proposed country-specific recommendations. I invite you to read some of them, addressed to, I think, Italy and a couple of other member states, where this theme is very much present. What does the Commission, again, the Commission, through the EASY program, provide some funding, financial support to projects in that area as well. This will remain, so we will still have a budget for that, and we will still organize calls for proposals and try to have good pilot projects, and if they are good, sell them, give them publicity, and so on, and this will remain. What about the platform? First of all, the platform, we, I think, in the Commission, are the biggest fan of the platform and its performance, so we want to keep it. We thought it useful to bring it closer to, or to move to another dimension as well here as well. This is a bit tricky because obviously the scope of ELA is cross-border, but then you will have noticed, and this is, I think, in recital, so I will become a bit technical, and sorry for that, but in recital 6, I think, of the in the regulation, we explain where the authority should perform its activity. So the authority should perform its activity in the areas of cross-border labor mobility and social security coordination, including free movement of workers, posting of workers, and highly mobile services. It should also enhance cooperation between member states in tackling undeclared work. Yes, cooperation between member states in tackling undeclared work. And we believe that this cooperation, which will be enhanced, will also have an impact on what is done at the national level, obviously. Then, what is the platform, the work program of the platform? So you know it by heart, I know it a bit less. What the platform is organizing, mutual learning projects, mutual assistance projects is more or less the same thing. We have staff exchanges, seconded schemes, exchanges, disseminations of experiences, and as well some campaigns, awareness raising campaign. And precisely all these activities, you find them in 2 different articles or tasks of the European Labour Authority. I will start with the task on cross-border labor mobility analysis and risk assessment. And then you told me that you were a bit disappointed that there was no reference on improve the knowledge and so on, but this is in the regulation. This is in the regulation, so please have a look at Article 2C, where the platform, the authority, shall organize peer reviews among national authorities and services in order to, a couple of things, improve the knowledge and mutual understanding of different systems and practices and so on. Okay. So this will allow, this is in a way the legal base for the authority to continue the work and maybe to increase.
Okay. Colin, I'll give you a chance to respond in a moment, but I do want to, we don't have much time, I do want to finish on time, so let me just see if there are any questions or comments from the room before we...
But if I could just add a couple of things, because and the other activities that the platform, and I went through them, the legal base, you will find them in Article 12, exactly the same wording sometimes that comes from the decision establishing the platform. And then the budget of the authority is 51 million. Huh? It's nothing to compare with the budget that we have now for undeclared work. Of course, all the budget will not go to undeclared work, but here there is room for additional action.
That does beg the question, you know, in terms of to what extent the staff, the resource is all new resource and new staff, and not just because it's not just the platform, but there are other bits that you are absorbing into this agency. To what extent this new authority has real, genuine new money, new resource, and is not just, if you like, putting old wine in new bottles. But Colin, briefly, if you would, because we don't have too long, but your face was a picture then while Denis was explaining what has been done and why it's been done. I'm assuming you weren't entirely convinced.
No, this is where Brussels amazes me. I'm just a naive academic. You know, if the Allah is going to do exactly what the platform is already doing, then why are we repealing the decision? Anyway, I will leave it. Let's move on to other subjects.
But that does, Denis. Okay, on a broader question, as I don't see any hands going up at the moment, there will be, obviously, this is a passion and a concern of Colin's. There are other areas and other parts of agencies and bodies that you're absorbing in some cases. How will you reassure people that this isn't just, if you like, almost a repackaging exercise? You've taken these things and put them into this new body, but it doesn't, you're trying to argue here, it doesn't fundamentally make a difference. So why absorb it? And not specifically now this platform, but why have you gone down the road in some cases of absorbing part of the Eures coordinating office? It comes in. Some things come in and some don't. How did you decide what to bring in and what to leave outside and then coordinate, is my broader question.
3 words. It's one-stop shop. This is the idea behind the European Labour Authority. You will maybe remember, if you studied some literature, the classical approach, so the unity of time, place, and action. This is what is behind the ELA proposal. So we want to have a body that will allow to bring closer different policy fields, posting, free movement of workers, transport, and declared work. And with additional means, if you compare to the budget that we have now for all these different activities or sub-activities, and the one that we propose for the ELA, nothing to compare. Unity of a time, yes, because in this era, and this is what we can read in the newspapers or hear on the radio every day, labor mobility is a sensitive issue. I mean, I've been following a bit the discussion, the campaign in the UK 2 years ago, and labor mobility was quite high on the agenda. I've been following the French campaign as well. This is an issue. And then there will be the European election. So we need a body that provides quickly some solution action. And then unity of place, yes, this is the one-stop shop. This is the single phone call number. So through the national liaison officers, there will be people, experts, which will be able either to provide or to liaise with those who know the replies to the issues that has been raised. And of action, yes, of action, because in those different areas, we need to be more reactive.
Thank you very much for that. I don't know if anyone wants to react to that. And if not, we'll try and draw some conclusions from this session. Any reactions? Walter, did you want to come in on the explanation of what's the logic behind bringing some things under the umbrella of the new authority and so on? No. Okay. Let us try now to, and it's the same question really to all of you. You've all raised a number of issues and a number of challenges. We heard about the challenges in the first session. We've put flesh on the bones of that and some of your concerns about the proposal. Denis started by saying, when he was explaining why the Commission had decided to act, he said, it is time to move up a gear. That's what we decided, and that's what we're trying to do here through the creation of this agency. If this new agency, and I go back to Agnes's words at the beginning of our event about if we are to ensure that this is a serious and an effective authority, what for you is the one priority in terms of a key ingredient this authority must have, whether it means something that must stay in the proposal or something you'd like to see changed in the proposal? One thing we need to do to make sure it is both serious and effective in dealing with the problems we've discussed. Walter, I'd like to start with you. What is your overarching priority and why?
Yes, the hottest problem for Austria, I'm from Austria, is the execution of penalties cross-border. Yes, because now we have the situation if there is an infringement of a company, and if the competent authority controls this and it makes a procedure, and at the end of the procedure there will be a penalty. And then of the one side, we have companies in Austria where we can execute the penalties. And on the other side, we have companies from other member states where it is very difficult to execute the penalties. I know we have the enforcement directive, but the enforcement directive says that it is mandatory to execute the penalties in a cross-border dimension, but our experience is that this does not work or does not bring some difficulties. And so the danger is that Austrian companies say, okay, if there is no way to execute it in other member states, then we will register a letterbox company in Bratislava or in another member states, and then we can do whatever we want. And so this is the most hottest problem at the moment, and I think it's very necessary that we have an authority to look at this, that this will work in practice and not just on the paper.
Thank you very much. Lena.
For us, the objective of the Labour Authority should be to improve workers' protection. And to do so, the officials must have the sufficient mandate to detect and to deter fraudulent behaviours. I know I've been really critical throughout the panel, but one thing that I would like to thank the Commission for, not only putting the proposal forward, but actually including us, the social partners, in the advisory group that is going to look at how the Labour Authority should function, and to try to put some meat on the bones. And I must say that this is appreciated, and we have every intention to use this opportunity fully.
Thank you very much, and thank you for being critical, because the point of this discussion is to work through this proposal and see, as we said at the beginning, does it meet the challenge, and if it doesn't, what can be done? But it all started with you all being positive about the fact that it exists and the added value. Colin, you talked about it being this holistic approach, which you very much welcome. So I'm going to jump over Denis, because I'm not sure if I can ask you for a priority, as you are more in listening and reacting mode, but if you give me a personal priority, that would be marvellous. But I'll jump over you first. And Colin, your overarching priority and why?
Okay. I'm going to frame it. You said to move up a gear. So what is really needed to move up a gear? I think empowering national enforcement authorities to conduct a few cross-border joint inspections is not going to move us up a gear. What will move us up a gear in worker protection and tackling labour abuse is improving the capacities and the capabilities of member states to prevent labour abuse and protect worker rights. So that would be my priority.
Thank you. So we go back to that point. It's compliance, it's prevention. We need more of that. Denis, let me put it slightly differently to you, perhaps. In terms of as this proposal now goes through the legislative process, if there's one thing in it that you feel, personally having worked on it and clearly being very passionate about these issues, one key ingredient that you would emphasise and say, please make sure that that survives this process, that's absolutely central to making this work, what for you is the most important overarching priority as this goes through the process, if you can tell us that?
The repeal of the decision establishing the platform. No.
See you outside.
No, look, obviously this is a package, and this is difficult for me to choose all the 7 tasks that we have identified are equally important. What really matters to us is the finalization of this process, which has just started. And what we saw, especially in this House, is very promising. So we see an ambitious timetable, and we will obviously cooperate loyally, and if need be, provide any kind of support replies, and as well to the legislator, co-legislator, and this would be our priority, so to finalize the legislative process as soon as possible.
As you say, a very ambitious timetable coming to the end of a legislative cycle, so you need to do it quickly if you're going to do it at all. So speed being of the essence, let's get on with it, if we can put it as simply as that. Ladies and gentlemen, will you join me in thanking our panel very much indeed. Thank you to you all. And as you make your way back to your seats, I'd like to invite the man with the unenviable task of putting all this together and thinking in terms of the implications that we'll have. Georgi, would you like to come and join me here, or do you want to speak from where you're happy where you are? Georgi Perinsky, who, as I mentioned earlier, is the shadow rapporteur on the EMPL report on this proposal. Your thoughts before we close, please, after a very challenging debate.
Thank you very much, and I'd like to join you in thanking both panels. I believe it's been a most useful exercise, if I may say so. The first conclusion or impression that I at least come away with is that there is a diametrical divergence regarding the very essence of the problem. The Commission seems to feel that we have all this legislation passed, posting, etc., etc. Now it is a matter of, in a way, smoothing the way it is implemented. And Article 1, more or less, reflects this. The authority shall assist, not even support, but help, Member States and the Commission in matters relating to cross-border labor mobility and the coordination of social security systems. Matters relating to cross-border mobility is the way the Commission sees it. What we heard in panel 1 is that we have before us a monster, a fraudulent criminal social economic model of doing business, which requires clearly a commensurate degree of reaction. So here, first of all, I don't think we're clear as to what we are talking about. This comes to the second, so to say, conclusion that therefore we need a mapping exercise. We do not know exactly what we are talking about. And here there are two, so to say, points of view. One is, so to say, fair mobility, and how do you go about seeing that those stipulations in the various instruments are implemented, national authorities, etc. However, this is a one-eyed approach because there is the whole world of unfair mobility. And on unfair mobility, we are excruciatingly silent, we, the Commission. And the litmus for this is exactly the platform of undeclared work. The explanations we heard are, I don't want to qualify them. They simply are nonsensical because the platform, in the very detailed way we went about designing the decision, had the task, first of all, of precisely mapping the problem, understanding what we mean by undeclared work, because the definition of 1996 is absolutely outdated and will be becoming more outdated with the whole world of platform work. So, to simply say that we have copy-pasted some sentences from that decision into one or another article here, to me is, I'm sorry to say, totally irresponsible. Number three, I don't think that, there is this very strong point made by Colin Williams as to enforcement versus prevention. And this is something also which we went into when we decided the platform. Because under the word tackle, there are two first words, prevent and desist, discourage, and then there are sanction and react when you have not been able to prevent it. So this approach should be very central to what the platform should do. The way it should function, now the seven wonders of the world clearly don't stand up to any kind of comparison with what the comparison to the banking authority has shown. We heard the argument of the 11 yellow cards in support of the notion of subsidiarity. And one must understand how come that happens. Are these 11 countries interested having their citizens being exploited? Is that the explanation why these 11 cards were given? Certainly not. It has to do with fundamental imbalances in the economies and in the payment levels between East and West. Once you have masses of people in Eastern countries not finding employment in remunerative, having to go to countries where the growth is and where the employment is. And then clearly this becomes an interest to the country for the transfers, both at the family level and at the national level, because in a certain amount of countries, these transfers are larger than the direct investment in a given year in productive. And here I think the whole notion and concept of this authority falls short of something which is declared in the explanatory note, namely that it is in the context of political priority number 4, deeper and fairer internal market with a strengthened industrial base, and in particular the internal market strategy. There is this approach once again is tackling one aspect of a deep imbalance in the way the European economy is imbalanced at the moment. Now, I'm not saying that until we reindustrialize, we have to accept all these infringements, not simply infringement, but drastic encroachments on people's rights. And here, of course, there has to be a very well thought out system of how one tackles this thing which was described in the first part. The letterbox company carousel business, the gross evasion of any kind of sanctioning, of any kind of accountancy, of any kind of bringing justice to criminal activity, because what was said was there is social economic criminality. And here again, we touch upon a broader field, because what we're talking about, in fact, is competition law, is, because the European Court of Justice, whenever there is a complaint about these letterbox companies, says, wait a minute, this is freedom of establishment. You cannot question freedom of establishment. So then you get the case where a letterbox company is caught in this kind of behavior. It promptly goes bankrupt. It is re-established someplace else, and the chain is broken. So you have these drastic examples of crass, behavior flying in the face of elementary notions of fair play, and a kind of total helplessness that you can't do anything about it because those are the rules. I'm sorry. This certainly, absolutely does not make any kind of sense. Then you get the whole issue of how this one stop, one shop, one time, one place, one thing will function. This also, the whole argument is highly doubtful, because as everybody knows, putting into one basket different offices, different authorities, which are for decades working in a particular way, getting them to work as one organism and making it deliver better than the way things are being done now is a highly dubious exercise. So yes, there is an argument of overcoming overlap, of streamlining, etc. But if you don't have the focus, what exactly are you trying to achieve, rather than these three very innocuous: information, cooperation, moderation, if you are clear that you want to regularize deeply irregular practices in cross-border labor mobility, then you decide exactly what you bring in and what you establish the necessary liaison with existing systems, so that, yes, you get the synergy, but you don't run the risk of creating an organizational monster. Furthermore, the common agreement which was mentioned of 2012, that it has been decided that there's a management board and there's an executive director and that's it. This is typical Brussels, which doesn't wash any kind of credibility with the end user. And I wonder whether we noticed that the end user, in the person of these people that were there, the drivers, we lost the end user in the second half. They were interested in the first half because they heard their experiences being described, but when they heard what is going to be done about this, their interest dropped to -0. I can tell you 3-4 weeks ago, there was a meeting with truck drivers. Some colleagues of ours organized that. And one of the Romanian drivers picked up a piece of paper and said, "This is the Charter of Fundamental Rights. Article says dignity of person. I find this," he said, "a sick joke. This means nothing to me," because of the way, on the ground, finally, after all the directives and the regulations and the agencies and the platforms and everything else is piled one on top of the other, they still are in the position which they explained to us. So what did our Dutch trade union person says? Boots on the ground, a social Europe police force. Now, I don't think that literally that is true, but if you want an authority, you cannot count on, I believe what Mr. Ganton in French was trying to say, the authoritative voice, or the voice of authority. The pronouncements from this Mount Olympus of the European Labour Authority saying, this should be this way, that should be that way, will carry the authority which will make those that are breaking the rule shiver, as our Dutch trade unionist was hoping that once they look at what's being thought about, they will be nervous and he will be happy. For the time being, I don't think he has any cause to worry that those that are breaking the rule will get worried. Now, the timetable. We are all, I think, in favor of ending this mandate with a European Labour Authority. And this is what we'll be working towards. I very much am committed to making every effort for this to happen. But again, I would like to be clear that any deal is a no-good deal. This deal has to make a difference. So those would be my takeaways.
Thank you very much, and thank you to our panels for outlining how they think this deal really can make a difference. Thank you for your very thoughtful analysis of what we've heard and what it means. There's clearly an enormous amount of work to do between now and getting to where everyone wants to get, with differences of emphasis, but I really would like to thank all of you very much. Thank you, Agnes, for hosting us today. Thank you to the team for organising it. Thank you to our wonderful interpreters for their very hard work. A round of applause for them, if you would, please, ladies and gentlemen. And thank you to all of you for coming, and have a very enjoyable evening wherever you're going. Thank you.
And
Great
thank you,
pleasure.
Jackie.
Thank you. Lots of work to be done.